And the Attorney General went to the annual general conference of the Ghana Bar Association. And the Attorney General, Mr. Ayine, Dominic Ayine, accused GBA of partisanship. And the Attorney General, GBA, Ghana Bar Association, the president of Ghana Bar Association, Nikunu and Joe Gate. Joe Gate was one of the contestants. Now one person bear flag bearer for the NPP. So that woman wanted Joe Gate to win the primaries for her to become the first lady. She is the president of Ghana Bar Association. So you should understand, she's technically an MPP sympathizer in and out. She can't tell me she wasn't supporting her husband to win the MPP primaries. First of all, she has been compromised when it comes to her political stance. She's married to an in and out politician who wanted to lead the MPP, which was in power. But that is a conversation we'll have another time. Now, Attorney General, when he went to the event, he spoke boldly about Nyomebia Ghana Bar Association. Today, we all know, Ghana Bar Association is one of the most useless associations in Ghana. Majority of the people who are members of the Ghana Bar Association, they know that the association has collapsed, the association has no credibility, the association has become very partisan, and that the leadership of the association, they have sold the integrity of the association because most of them are aligned to politicians. Now, for a long time, we were waiting for one person to be bold, to tell us, all of us in the face, to tell the GBA in their faces that this association is a waste of time. We were waiting for somebody who was part of the association to break that news to them, for them to understand that the Ghana Bar Association is one of the most useless associations in Ghana because they have allowed politicians to infiltrate, and that their legal reasoning has become one of the daft things that we have witnessed over the years. The Attorney General today spoke, and then the president of the Ghana Bar Association, Joe Gate, also responded. But before, let's listen to the Attorney General, what he said. After that, maybe the response from the GBA president.
We risk undermining the very foundation of our professional credibility. We must remember that our allegiance is first and foremost to the Constitution and this Republic, not to transient political interests. Over 3 decades have passed since the adoption of our Constitution. During this period, our Republic has tested and continues to test the resilience of its democratic institutions. In doing this, the Bar has played a crucial role in assisting the Supreme Court to interpret and enforce the Constitution. But outside the courtroom, the advocacy of the Bar as a professional group has lacked consistency, bringing into question its adherence to principle. Ladies and gentlemen, when in 2015, an Article 146 petition was received by the Chief Justice in relation to the former chairperson of the Commission on Human Rights and Administrative Justice, Madame Loretta Lamte, the Bar failed to speak out about process. In the run-up to the 2016 elections, the then opposition New Patriotic Party engaged the Electoral Commission in court battles over the voter identification system. This gave rise to the Abu Ramadan line of cases. Immediately upon assuming office in 2017, an Article 146 petition was filed for the removal of the chairperson of the Electoral Commission, Mrs. Charlotte Osei, and her deputies from office. The Bar saw no basis to speak out about compliance with due process. But in recent times, the Bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice, Mrs. Gertrude Araba-Tokono. Ladies and gentlemen, the honest question we have to ask ourselves is, what changed? The 3 petitions aforementioned touch and concern office holders of 3 constitutional bodies critical to the sustenance of our democracy. The independence of the 3 institutions has been guaranteed by the Constitution. The 3 occupants were all women of significant repute and members of our noble profession. The 3 committees established pursuant to Article 146 complied with the constitutional procedure to the letter. And yet, the bar found its voice only in relation to the 3rd petition. Coincidentally, the voice of the bar amplified the voice of the opposition. The lawyer in politics must be a voice of reason, moderation, and constitutionalism. The bar must speak out not to please governments or opposition parties, but to defend the rule of law, the independence of the judiciary, and the rights of the ordinary citizen. The Ghana Bar Association is not merely a professional body. It is a moral compass of the legal fraternity and a key pillar in the construction of our constitutional democracy. As Lord Denning once wrote, and I quote, "Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking that the judge was biased." The same applies to the bar. Our authority as a profession depends on public confidence that we stand above the fray of narrow partisanship. Let us therefore be the conscience of the Republic, fearless when governments overreach, impartial when opposition agitates, and always faithful to the sovereignty of the people under the Constitution. And talking of sovereignty, we should desist from the temptation of inviting foreign interference in our internal constitutional processes. As a professional body, there is absolutely nothing wrong with forming relationships with like-minded foreign associations. Such relationships are necessary for cross-fertilization of ideas on professional matters such as standards. That is where it should end. Interference in constitutional politics risks violating the principle that sovereignty resides in the people of Ghana, in whose name and for whose benefit the powers of government are to be exercised.
Please at for Kevin, where dear brother Dawson, you been then what happened quiet. MPP for do one air chairman Kevin at Churchim, I dear channel of Kwasiakwatana with Dimatem, but Ghana who don't see Churchim. And the Attorney General Echo Ghana Bar Association for a program. And now Okotu Nenum 2 H3 a Ghana Bar Association say, Nyachomono Munjai. In fact, Okasan or say, a year association, our allegiance no, is to the Constitution. Na enya political party bi ana political party ana ekuobi. Into no also since onim eye Ghana Bar Association no. Sa association de na nka omo de omo gina ho ema constitution no. Say ye be kirem omo boa Supreme Court omo ma kirekire eye de emram na omo hye omo kakra gina omo chi omo hye mra. Omo say sa nyoma ne bi intina eye Ghana Bar Association omo teye. Na ya nte ba ne say ye de ba be ye politics. Okwo denim no say Sir, or turn initially chair as a member of the bar or good standing from Titina on men and inquiry from 2015 a bar no started year politics. Started free a year 2015. Okay, a year Abu Ramadan in Seme Babaye. I did moi a bar no, and then who did moi ebedu 2017. Charlotte say, Omujina so, Omumubi started 2 Omano SC Charlotte say so, say young Pamo Charlotte say, or say, o kabano ho na de ba ne ye ne say omo na omo start ekeka sansem no ema sambre no President of the Republic activate Article 146 original so ema constitution edi na djuma ye de pam shaloto say o say eye Ghana Bar Association sa asem si no omo gina ye esore ye ekasa say president no ne kwan aso no efri say we gina constitution so aye the constitution ne pe. Into Obusa a Ghana Bar Association in the say a day at the same association Article 146 and another Danko for the Gina 2017. Eddie Pamo Charlotte say the same Article 146 and John Dramani Mahama a Gina so Eddie Jumano the same bano and the Asori Etia John Mahama buying. Or see Ohuni say and a Ghana Bar Association a bear 2 partisan Omudu Omu Afra a political parties. omo mpedifo mu di anim aye sikadie krono ene nyoma bia omo ya airtime ene emrane da hokura na Ghana Bar Association penifo mu di anim ene association as a whole no omo sheda abo emrana to nchen edi omo kuma ene omo feelings akansem abra edua edibo techi no osanka o sa dua na edibo ban no ene Ghana Bar Association say edua na edibo techi no ye bebo ban da dia Ghana Bar Association so omo ntiase also ya attorney general asem no ha no if so who say Ghana Bar Association ende adane dwirim ene eye pesem minkumnya eye nhwehwemu ene sebio eye ade bi omo ya broni beka say omo ya sycophants omo ya hypocrite omo mpese omo beka no kore na o kan bibi o see time ye Charlotte ye eye Madam Toko no asem ba ya president edi mra no so fenchem no ade bi a esi ye ne say MPP as a political party no na mankasa from beginning no omunim say emra no president any Ghana man no ye di mra no so pepepe the constitution so na emom no Ghana Bar Association almost started ye the politics and partisan politics ewura process nim if you say or see time na seven started say Madam Toko no say ofamre mu no petition ne ba no petition ko di president edema the council of state hwe mu no say ampa we the asem no ayese bibi wo ma ombetuma di akire and omode ma president and a president gina constitution so ethics committee and a committee no eje ekohwehwe nsensem no mu etotototo Toko no ano etotototo omo chiro petition so ano omo wie na omo chiro the omo findings send your omo hu de bia emfimfimu no ba no the omo board tofa and I'm the president him say only constitution so not the omachro no omani nyadwuma and a president no edi constitution so and the committee no findings of the buy no odi so eye adwuma into osina eye no nwanwa say eye de eye Ghana Bar Association ejigine mu bare na okan brofo bi o say the voice of the opposition amplified because o say eye MPP for no omo voice and as almost started can some atro emane yet to say Toko no process okom no partisan if we say Ghana Bar Association and a almost sad to me no if we say Ghana Bar Association and a start ye de omo anshada line ti omo anka no kure no engina no kure so na omo imagine say abaye di bo techi no omo pese de bebo banti na omo kinka nsam no in a way na MPP for no so efa boni ewo mu no na omo di dwuma na okasa no o say the ya ni ya e wona kuma mu say Ghana Bar Association beko UK na omoni the association bi wo ho akofa adwene say ye constitution ye nananom ekekere de ma ye say ye fa man no ban no omama the association bi wo UK ma ye ne Ghana for instruction say omoni Ghana Bar Association aka omutirima bomu say ye ne constitution no omo de omo pen na yenye o say eno ene twa ne nsum oye nipa bi a ontia se Ghana oman no ye ne sebio ekuo mo amaman so ebedwendwene nyoma ho na mum se ne Ghana Bar Association ebeko UK ene de ekuo bi akoko mutira bom abe undermine anase omo be bu Ghana nimtia no o se ha no every say ebasara na Ghana Bar Association omo be ye de omo be ye kwankro omo be ye disease omo be ye adibia ehuma Ghana fo into ono oye attorney general no o ka che Ghana Bar Association say de omo ye ne de sebio association egu emu nipa omu di enim na oso omu ferry na ono oya attorney general no sadia Ghana Bar Association na aye no akire se Ghana hayete no Ghana Bar Association enimonyama omu wo no sa enimonyam no de yemfa nto binim evi se omu mpanifo omu di enim no sebio omu ndi ne kure e na omu mwa Ghana ma yekebi memikebi no enkoso attorney general Mr. Dominic Ayine e kan nsem we nyina wie no e na Jogate yire a ono de the president of the Ghana Bar Association ono so kwaje Mike say and ono so ebe kirechirem a kire adekudie ntia omudi sa abone no na momentie sa maame no so asem.
The Constitution of the Ghana Bar Association enjoins us to protect the independence of the judiciary. This is a duty the association does not take lightly, and from time immemorial, the bar has fiercely performed this duty. My learned friends, we are all aware that Article 146 of our 1992 Constitution has come under severe scrutiny in recent times. For the first time under the Fourth Republic, it's been evoked in respect of a Chief Justice. The position of the bar must be stated clearly in this regard, The bar recognizes the fact that the power of removal can be exercised under Article 146. But the bar's major concern relates to the process. In the absence of specific rules of procedure, the sketchy process potentially lends itself to arbitrariness and a lack of fairness. Hence, the bar's resolution on the matter, which was as follows. The Ghana Bar Association hereby also calls for the immediate enactment of clear and comprehensive regulations relating to matters under Article 146 of the Constitution of the Republic of Ghana to ensure transparency, accountability, and fairness in all proceedings involving Superior Court justice, particularly in the context of the impeachment or removal of such officers. This resolution was passed and publicized by 30th April 2025. However, no rules were produced. It is commonly said that justice should not only be done, but manifestly be seen to have been done. The lack of an enactment for such rules in the case of the removal of the fourth highest person in the nation should be a matter of concern for all of us. These rules should have been known to all and sundry before the commencement of the process, as it greatly affects the standard to be met. It ends up being an unfortunate precedent which lacks fairness, a situation that calls for redress if indeed we are custodians of justice. We all deserve justice, from the well-endowed in society to the less endowed, from those who wield political power to those who don't, from those who have economic power and those who don't.
Now, the mami we can no say Article 146 Ghana Bar Association omuntia Article 146. That's fine. Almost any problem biya with say ye di Article 146 so our constitution mu ene de omugitum na okasa no o say major problem pa ne say Article 146 no fine na toko no asem de bae no their major concern about process no. Now what she failed to elaborate on was which part of the process they as Ghana Bar Association have a problem with. You see, the Ghana Bar Association, they've been hiding behind words. You cannot just vaguely say you have a problem or your concern is about the process. If the Ghana Bar Association, which is made up of lawyers, so-called intelligent lawyers who know the law, the first thing they would have stated was the flaws in the process. The exact flaw in the process. At the original classroom, na teacher actually ABC, nobody said, you understand or see? No, the whole process. When you say that, that means class standard what's in the crampon, you are not supposed to be there. Now, if you are a legal brain, if you say you are a lawyer, you recognize Article 146, you have a problem with the process, you should be able to specifically point to which part of the process that you think was skewed. But you cannot vaguely just come out and say, we are Ghana Bar Association, we are against the process. Which part of the process are you against? The reason why some people had the problem with the removal of Charlotte Osei, the process was that Nana Addo Dankwa Akufo-Addo did not even give Charlotte Osei the opportunity to look at the petition. That process was tainted. Secondly, the people who even wrote the petition, Charlotte Osei did not even know who were behind the petition. That was a breach in the process. During the process, the Chief Justice then, Sophia Kufu, warned Ghanaians that nobody should speak on the process. That was gagging the system. That was also a breach in the process. Sophia Kufu, who was the Chief Justice, selected her own people to be on the committee. It was a breach on the process. Now, the process we have today, John Mahama and Ghana, our constitution, the president gave Tokonu 10 days, even though Tokonu asked for 7 days, the president gave Tokonu 10 days, gave her the petition. Tokonu knew the petitioners. Tokonu was given room to read the petition. In fact, Tokonu was given the opportunity to come in front of a committee. During Charlotte Osei's hearing, Charlotte Osei basically went, Charlotte Osei's issue, Charlotte Osei went to the Chief Justice to ask for the petition. Sophia Kufu Beifuanakachen said she's not going to give to her. Sophia Charlotte Osei went back to the Jubilee House, asked Achichidi Ekufuado that she wanted the petition. Ekufuado said he did not have any petition. But in this case, Tokonu was given the petition by the president, sealed, and given more days to look at the petition. After that, the president put together a committee and gave Tokonu the room to get her own lawyers to go in to meet the committee for the hearing to be done. So if you're talking about the process, madam, which part of the process do you have a problem with? You know what they are trying to do? They are speaking vaguely because they don't have exact breach. The president follow 146, Article 146, they cannot pinpoint exactly fault our president, and our constitution, and our making sure the process. They don't have anything.